Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I provide online divorce mediation and valuation services based in St. Louis, Missouri. Today, we're going to discuss the marital balance sheet, trusts, and divorce with Bob Boyd and Tish McDonald from Atlanta, Georgia. Bob is a co-founder of Boyd, Collar, Nolen, Tuggle, and Roddenbery, and a leader in family law who has received recognition from his colleagues across Georgia and the nation for his work in high net worth divorce litigation and contested custody cases. Tish McDonald is a partner in the trial and global practice group at King Spalding. She focuses on complex commercial litigation with an emphasis in trust and estate litigation. She also gets involved with litigation for nonprofits, real estate, and government entities. We start to see the trusts and family trusts start to enter into family law. And it's this separate, and it could be a separate and marital issue, but you start to see either trusts that the families create internally or even parents and grandparents. Tish, can you tell us a little bit of where you're seeing some of these trusts get that we even have to look at them in a litigation situation?
Sure, Melissa. Typically, when I'm just a litigator, I'm not the family lawyer nor the planner, but when we get brought in, it's because there is a question about how third-party property, which is trust property, can be properly characterized. And usually the non-beneficiary spouse will go, wait a minute, my spouse's interest in a trust ought to be characterized as marital property, subject to equitable provision. And generally, there are two types of situations that you deal with. Of course, it's an irrevocable trust. Let's start with that proposition, because if a spouse has set up a revocable trust and has the right to revoke it, then that's marital property because that spouse has control. But where Bob and I come in and start dealing with this type of situation is when it's an irrevocable trust. And to take your example, Melissa, which is a good one, is what happens when a parent or grandparent has left a will and sets up an irrevocable trust, let's say with a bank as a trustee, and leaves property for the benefit of their 3 children. And let's assume one is getting a divorce. If that trust provides for mandatory distributions of trust assets. For example, please pay the net income to my 3 children divided 3 ways quarterly until they die. And it's a mandatory distribution. Then that distribution is marital property. Okay. But if the distribution is discretionary with the trustee, and again, assuming it's an independent trustee, the bank is discretionary, meaning they can decide, the spouse doesn't decide, then that distribution is typically off limits. I will go ahead and mention a tricky situation, which I've not encountered, but I've heard of, is what happens when you have, and again, using this example, you have a trust established under the will by a grandparent or parent, a bank is a trustee, they're discretionary distributions, but the trustee has been very consistent over years and years. I'll give a rough example, $100,000 a year to the children each. So the divorcing spouse is going to say, wait a minute, it's discretionary. That can't be marital property. But the question becomes, could a family court view that or take consideration of the fact that it has been ongoing and part of the support of that spouse for years? Again, I haven't seen that, but I'm aware of a Colorado case where the Colorado court said, well, I'm going to let the family court take that into consideration in dividing assets. Not necessarily declare that, take into consideration.
That's what I was, and to be clear on that, if you ended up in court, a judge is not going to say to the non-beneficiary spouse, not going to enter an order that says, hey, Ms. Trustee, now give divorcing spouse 1/2 of her husband's distribution from the trust. It doesn't work like that. She's not becoming a beneficiary of the trust. A judge is just going to say, husband, pay her X dollars in child support. I don't care where it comes from.
Right.
Well, and I think that Tish alluded to it a little bit when she started off very professionally saying third party entity or ownership or holdings, because, you know, in some respect, these trusts are their own freestanding entities, right?
Correct.
And what's happening is, yes, they are created in this estate planning environment, right? And everybody's providing for their children and grandchildren going forward. But then there's a divorce either in the owners, you know, the beneficiaries, the trustees, and all of those terms are very important.